giving them the right.
Then that is not
Or
what I'm saying. Both are
both?
guilty
Okay.
if found. Both, let me say, can be accused of committing wrong.
Okay.
You understand? So both. So if you are actually interested in protecting the environment, then why should you leave those who were found engaged in the act and they themselves have even testified before the court that yes, they were doing it, but just that they did it, and it's just like saying if you go to the site and you find the boys who are doing it because they have sponsors somewhere, the guys doing it are not guilty of an offense. They are, in as much as the kingpin is also may also be guilty. Let me put it that way. So that's what I'm saying. So looking at it holistically.
But have you read the judgment?
Yes, I've read it fairly. I've gone through it.
Do you have any issues with the judgment?
Yes, I have some issues with the judgment, which I think if I were to be a lawyer for Wontumi, I'll pursue an appeal.
Which issues do you think they can use to appeal? On which can form the basis of an appeal? The issues.
Yes. One, the people or the Attorney General charge was that Wontumi had assigned what do you call it? Mining rights to those people to work. But I don't see how the judge resolved that issue and came to a conclusion that yes, he assigned them. Because when you are assigning rights, mining rights, like a lease was assigned to Wontumi, Minerals Commission cannot assign a lease to Wontumi by word of mouth. It should be documented. There should be documentary evidence. So, for example, if I go to the Minerals Commission and the boss over there, the minerals say, "Oh, go and take this and go and mine on this land." By the mere say so, can I say that I have been assigned a lease to go and mine there? Certainly not. Secondly, reading the judgment, I realized the judge was trying to find where it was comfortable for her. That is to say, when it came to the issue of piercing the veil, the court was trying very hard to get a reason why Wontumi should be touched. I say so because when you read the laws on which the judge stood, the court or the law is the accused person, he can even choose not to say anything. The onus of proof lies with the prosecution. So in a criminal trial, it is not on the preponderance of the probabilities, but rather that the prosecution should rather make their case beyond reasonable doubt. So you don't tell me that the prosecution or the witness made this statement in his witness made a statement in the witness statement like he gave it to me, and that the counsel for Wontumi never cross-examined him on it. The counsel need not cross-examine him on it. The fact that they stated it in their witness statement is not proof enough. It is upon them to then establish the fact that they have put in. That is what we call evidence. So if they were not able to establish it by themselves, it is not for the court to say that because the lawyers did not cross-examine on that issue, they are settling it against Wontumi. If it were to be a civil trial, that would have been correct. Because in civil, if an allegation is made against you and you keep mute, it means that you accepted that what the other person said is true. For example, if I make a claim against Senna, that Senna took 10,000 cedis from me in a civil matter, I want to recover my 10,000 back. And you don't dispute the 10,000 that I took, I'm saying you took from me, so you have accepted. But in a criminal jurisprudence, it's not like that. That is why the accused person has the right to even remain silent. It is up to the prosecution to prove their case. So if the accused person chose not to speak about it, you can't resolve it against him. The judge should have shown us the evidence that the prosecution supplied to justify those issues that they were talking about. Yes, then it will make it, in my opinion, lawful. And I think that is also another angle that lawyers for Wontumi can look at. I'm not too sure, but I think it was over the 90s I was trying to read, but the tail end of this thing, he was also making reference to, I think, Section 59 and stating that, yes, under Section 59, he has committed an offense. But did they charge him under Section 59? That's the question also. They charged him under, I think, 99, 2B, and is it 14, something. Did they charge him under that? So I think there is room that they need to pursue. That's what I was saying.
So, okay, on the matter of Section 59, so that we bring this to a close, you're suggesting that if you are not charged under a law, which is maybe a section which is part of a bigger law, the judge cannot go and say, if when you look at this portion too, he has a question to answer, or this part of the law, the judge cannot do a holistic application of the law. He can only pick the parts under which the person was charged. Is that how it works?
I would love to read that portion again. If he convicted on the Section 59, then the question I'm asking, was he charged? Because he has to be convicted on the matters he was charged on. So, for example, if there is an armed robbery and somebody was also sexually abused, and the Attorney General decides to charge him with robbery, simpliciter, the sexual abuse never came in. But in court, it came to light that he even confessed, yes, I sexually abused this person. It doesn't give the judge the right to convict him on sexual, because he was not charged. You come to court to defend the charges for which you are before the court. And not, that's what I'm saying, the 59, I need to take a good look at it. In fact, I was feeling, I was very tired around 1 a.m. that I was reading. So I have to take a very good look at it and see how it was applied.
On the matter of piercing the veil,
you charge under one offense and you convict under a different section.
Okay. On the matter of piercing the veil, I think that has to do with whether or what does that have to do with? Is it whether or not Chairman Wontumi has is it ownership or was involved? How does it apply?
And you brought me to a point. You see, when I was reading it, I found something very funny. Because when the judge started resolving the issues, I think the first one had to do with, yes, that Wontumi permitted him to work on the land. When I was reading, what was coming to my mind, what happened to company law? Is it the case that a company, a director of a company, so moto, can give what belongs to your company to another person? For example, if Wontumi has sold that land to him, his company, Akonsa Mining, could have come back to retrieve it because it has to get a board resolution. So I was asking myself, Wontumi's permission, was it backed with a board resolution? The judge never made mention of that aspect of the company law. I kept reading, and I realized that now the judge was making reference to company law when he shifted in a way the prosecution that by company law standards, the bill can be pierced because Wontumi is seen as one and the same person. When under cross-examination, the same judgment, the PW1 and PW2 was asked whether he knows that Wontumi is separate and different from the company. His answer was, yes, I do. So you are dealing with a person knows the principles of company law, who knows that Wontumi in his capacity cannot give him any right to do anything, knowing that the land or the concession is also for a company. Why did the judge decide to turn a blind eye? Remember when I was speaking, at a point in time, I was dragging because I wanted this point. It wasn't coming straight to me. Why will the judge do that? So it's like he selects the law where it will favor the Attorney General. He applies. Look, how can you say that the Wontumi never showed any? It shows that Wontumi is in total control over Akonta mining, and that he is not working with anybody, and that he did not show any evidence. Is it the case that Wontumi has to show any evidence to show as the accused person that he is working with other people? How can the judge make this general statement when you are presented with one case? You make a general statement that he's working with no board. What if there are other transactions that the other partner had a say in it? I think if I were the lawyer, I would go on an appeal. This judgment, I find loopholes in them.
How well do you know Wontumi?
How well?
Do you know him well? Well enough?
From afar.
Oh, you've never dealt with him before?
I've never dealt with him before. No. We've spoken once on phone, and it had nothing even to do with politics. It's a letter that we served him because we felt a member of his party in the Ashanti region was doing something untoward. He took the letter and he called me that, he has received a certain letter from my office, but he doesn't know what it's about. Aside that, I've never had any interaction with him.
Okay.
Yeah.
Thank you for speaking to us.
You are welcome.
Kwesi Kwakye Serbeh is a private legal practitioner, a member of the MPP communication team. Join us on the line. Taking us exactly 46 minutes past 8. SM.
Yeah.
You have been listening.
Yeah.
Your colleague lawyers have been speaking.
Yes. Many colleagues.
What do you think so far?
Oh, Sena. Former Land and Natural Resources Minister Kasai.
Okay.
Obie mani emameti ne baby asese even emra krom de ye adwuma sesi sentence when it comes to sentences no Gloria Kufu den and some buy ya bie mu they say from 20-25 years and just
yes
okay and Chama Wontumi answer me.
I'll come back to you because we are having. Let's speak to lawyer David Ametepe.
Me another learned colleague. Yeah, another learned colleague.